time is now 1 o'clock, and for the sake of time, I would like to call the Nurse Practitioner Advisory Committee meeting to order. I'm Samantha Gambles-Farr. I'm the chair of the committee, and I would like to do roll call at this time in order to establish a quorum. Vice Chair, Dr. Edward Ray.
Here.
Sally Pham. Jan Johnson Griffin. Dr. Andrea Espinoza. Dr. Espinoza. Kevin Maxwell.
Present.
And Betha Schnell.
Can you hear me now?
Yes, we can hear you now, Dr. Espinoza.
Okay.
Thank you.
Thank you.
Then I'm just waiting for a response from our public member, Betha Schnell. I see her on.
It shows that she's unmuted as well.
Yeah.
So I don't know if there's audio issue. I'll ask board staff to reach out and
Okay.
assist.
Thank you.
And, we have enough to establish a quorum, correct?
Correct. And
Yes.
has been established and the meeting is called to order at 1:02. Moving on to our agenda item 2.0, I will turn that over to the moderator. Moderator.
This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the committee reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. We do also have a public access. There's public access in our meeting room in our Sacramento headquarters, and we have a way to communicate in there with them. So we will query if there are any public members there as well. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then proceed to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. When your turn comes, you'll be prompted to unmute. If your question can be answered by the committee, will respond accordingly. When making your comment, speak about anything you believe is important for the members to know. Remember, committee members cannot address any item not on the agenda, items not on the agenda at that moment, and items that you would like to add to a future meeting, or items that will be discussed later on the agenda will be discussed at their correct times during the meeting. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when committee members or BRN staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will mute your microphones automatically. Thank you.
Thank you, moderator. Moving on to our next agenda item, we will take public comments for items not currently listed on the agenda for today. These are specifically items for future agendas. Moderator, will you please open up the public comment forum, please?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment."
This is Reza, legal counsel. Sorry to interrupt, but just a side note, housekeeping issue. Um, just wanted to ask our committee members for the duration of the meeting, if you have the ability to remain on camera, please do so. That's actually one of the legal requirements that allows us to do these meetings remotely. So if you have any technical issues or something like that, or broadband limitation or something like that, that's fine to go off camera. But otherwise, if you can, please keep your cameras on. Thanks.
Thank you. Committee Chair Gamble Spar, there are no public requests for comments on the WebEx. I am informed that we have no public representation at the Sacramento headquarters, so there's no request for comment there either. Would you like me to close this window?
Yes, thank you, moderator. And thank you, Reza, for that point of clarification. We are moving on to our next agenda item 4, which is to review and vote on whether to approve the previous meeting's minutes. That was included in the packet that was sent out for public review as well as committee members' review. That will be, that's listed from September 12th, 2023. I'm sorry, who gave the motion to approve, please?
Oh, this is Edward Ray.
Thank
Motion
you,
to
Dr.
approve.
Ray. May I have a second, please?
Jan Griffin, second.
Moderator, will you please open the forum for public comments?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comment. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in "I would like to make a comment." Committee Chair Gamble Spar, there are no public requests for comments on the WebEx. We have no public requests for comments in HQ Sacramento. Would you like me to close this window?
Thank you so much, moderator. Please close the public comment.
Thank you.
And so we will move on for vote to approve the minute meetings. Samantha Gamble Spar, aye. Vice Chair, Dr. Edward Ray.
Yes.
Sally Pham.
Yes.
NP Jan Johnson Griffin.
Yes.
Dr. Andrea Espinoza. NP Calvin Maxwell.
Yes.
And Public Member Betha Chanel, please. E.O. Melby, were we able to figure out if Betha Chanel is actually on the call, or is she just having?
To reach out to her, and there's been no answer.
Okay, I just want to make sure that for
Yeah.
clarification
We
that.
will.
Can I just ask, this is Reza. Betha, if you're able to hear the audio, can you like give a thumbs up or something? Okay, she can hear us. Very good. At least we know you're listening. We can either have her abstain on the motion or come back, or I guess vote by way of thumbs up or thumbs down. See a thumbs up. We'll take that to mean as a yes vote, and unless you clarify later on. Thanks.
Okay, and the minutes have been approved as written, and so voted. We will be moving on to our next action item, which is action item 5.0, discussion and possible action as secondary to the report of the Board of Registered Nursing Executive Officer meeting as it relates to the implementation of Assembly Bill 8, AB 890. EO Melby?
Thank you. So just some quick updates on AB 890 and the implementation of it. We're continuing to process applications, and the common reason for not being able to approve when they come through is based on national certification. The one thing to remember with our board specifically, there's only two boards in 2 states in the nation that does this. We allow for nurse practitioners to be licensed without national certification. Therefore, we don't hold their national certification on file with us. And because that national certification is not on file, we are not able to advance them to a 103 status without proof of their national certification. So that causes a delay while we are waiting for that national certification to be submitted. The other thing that comes into play with that national certification is that we are unable to currently accept retired or legacy national certifications to advance to the 103. There is a bill that was introduced this year that does remove that requirement and will allow for legacy certifications to advance to a 103. We will see what happens as the legislative session progresses. If that bill passes, we will go ahead and make the necessary changes to make that implementation so that all 103 NPs with a national certification, whether it legacy or current, sorry, I don't want to say current because legacy certifications are still maintained and are current. But the newer certifications with the legacy certifications will be able to obtain a 103. Trying to get to my numbers, I'm sorry, pulling that up. Other than that, we are still getting some reach out from committees, really just kind of discussing the process of a 103. We are noticing that as we are having outreach with the public, there has been some concerns around the 103 and the certification. So we're trying to just kind of wait and see what's happening with that. We haven't received official complaints yet. But with the meetings, what we're hearing is as hospital staff are going to onboard the 103 NP, they are reviewing their CV and their resume as part of the information to onboard them. And that on their review, they are saying that they don't meet the regulatory requirements and possibly should not have been certified as a 103 NP. So again, we can't say affirmatively about any of that because we haven't had official complaints. And obviously everybody is would require investigation. Everybody is innocent essentially until proven guilty. So we couldn't make a statement that say this is occurring, but we are hearing that that is something that is of concern out there. The other concern that we are hearing is that 103s are practicing in a nursing owned LLC. Specific to the group settings requirement that was set forth in AB 890 when that was passed, is it did not list a nursing owned LLC as a group setting. It was the medical owned LLC as part of the group setting. And so again, we haven't had official complaints on that, but I wanted to get that out in case there were nurse practitioners on this call that were aware of that requirement. In our business and professions code, it does have a reference to each one of the health and safety codes that were put into place by the passing of AB 890 that specifies the group setting that the nurse practitioner can practice in as a 103. It is not all inclusive. And so it is important that if you are wanting to practice as a 103, that you do so in the specified areas that were set forth in there. And so you will find that in the group setting, it is, trying to find it here. 20 Business Professions Code 2837.103. And it is lowercase a number 2. And it goes out and defines an A, B, C, D, and E, as well as an F of specific health and safety codes that describe the group setting. The one that I'm talking about here is D, and it says a medical group practice, including a professional medical corporation, as defined in section 2406, another form of corporation controlled by physicians and surgeons, a medical partnership, a medical foundation exempt from licensure, or another lawfully organized group of physicians and surgeons that provide healthcare services. There is not something in there that specifically mentions a nursing-based LLC. And so we wanted to make sure that that was out there for people to understand. When they do progress to a 104 setting, there is no workplace setting provision in there. You can work in any area. But you have to get to that 104 status first before you can do that. And then a reminder that we do not have any currently licensed 104 NPs in our state. We do not expect that to occur until next year at the earliest. And so if you do have an NP that you are employing or working with that state they have independent practice and can practice outside of those group settings, that is also incorrect. And so I just wanted to make sure that was there. Any questions for me? I am still trying to find that statistics. It dropped off my dashboard, so I just need to find it real quick. But I want to open up to questions or comments.
I have a question, Dr. Espinoza.
Yes.
This may be off the track, but I just want to check. So when people are applying for 103 status and they have legacy, do they go through the transition to practice as well? How does that get them through that part of it? Say they've been haven't practiced for 5 years. How does that get them through the transition to practice if they've been out not practicing for over 5 years, for example?
So I'm going to break that up into 2 questions because it's addressing 2 different things. And I'm going to say the big if that bill passes and it becomes law, that is just one component of what is required to move to the 103. All nurse practitioners must have a national certification in order to go to a 103. That is in addition to all of the other requirements for the transition of practice. So the 103 currently, the national certifications that are accepted are the 8 that are outlined in 1481 of our regulation. It does not include legacy or retired certifications. If we add legacy and retired certifications, if that bill passes, it only changes the national certification requirement. It has 0 effect on all of the other requirements of the transition to practice. The transition to practice question that you asked about the 5-year, if you have not been practicing as a nurse practitioner in the last 5 years, you would not qualify. It doesn't matter what your national certification is. The transition to practice hours, those 4,600 hours or 3-year equivalent, must occur within the prior 3 years preceding your application date. If those 4,600 hours fall outside of those 3-year time span, they do not get counted. 5-year time span, sorry, do not get counted. And they would not be able to progress. They have to be current in practice in order to advance from a nurse practitioner that's following standardized procedures to a nurse practitioner that would be working without standardized procedures within those group settings.
Thank you.
You're welcome.
E.O. Melby, just for clarification, the bill that you're speaking of, what would you share? Do you have that bill number? I have it written down here somewhere, but I've forgotten the number.
I
So-
do. I'm going to actually ask for Marissa Clark to be elevated. Really quick, 'cause I am frantically trying to find that. I believe it is a DCA wide bill. It's a, let me just find it. Wait. Marissa, are you up? Yes, it's the
Yes.
one that they added the retired legacy certification to.
Got
Do you
it,
know that
yes.
bill off the top of your head?
It is, I want to say it's an SB bill by Senator Ashby. It's like a committee cleanup bill from Senate Business and
Mhm.
Professions. And I want to say it's 1451 off the top of my head, but let me verify that for you real quick. Yep, 1451. So at Senate Bill 1451.
Thank you for that
And then-
clarification.
Marissa, can you flip me the email that has the stats on it? I'm dead in the
course.
water here. I keep looking and looking and looking and trying to multitask, trying to find it and answer questions, and I'm not able to find it in my inbox.
No problem.
And I know you sent it to me and had me all prepared.
I'm pulling it up right now.
Awesome, thank you. And I think the when I saw these stats and worked through them with Marissa, I think the biggest thing that kind of caught my eye is that we didn't have a lot of applicants for the 103. And I think that was not what I had expected, because we've had this up and going now for just over a year. And when you look at the nurse practitioner kind of population as a whole in our state, we have over 35,000, and our applications for those that applied to be a 103 were much smaller. So our nurse practitioner active licensees right now are 38,597. And the number of applications that we have received to date are 4,216. So our nurse practitioners that are in state may not be aware that this process is required, may not be aware that this process is available. We did send out messaging to all licensed nurse practitioners when this came out. So we've definitely sent the notification out, but the people are not applying. Additionally, the application's free. So financially, it should not be a barrier as well. But in 1 year's time frame, only having 4,000 just over 4,000 applications received when you're looking at a population size of 38,000 licensees, that was kind of shocking. And so I know in meeting with legislative staff, they're trying to find out what the barriers are to that. One of the discussions, a barrier was stated that these transition to practice hours must be completed after licensure in California and in California. That the transition to practice hours cannot be completed out of state or prior to becoming licensed in California. That is not a regulatory requirement by our board. That was a statutory requirement that was written into AB 890. So if that is going to change, that will have to be updated in a bill in the future, and then we'd be able to implement it, because it does state that it has to be done after they're licensed as as they're certified as an NP, and the hours are completed in California. So those may be barriers to this, where you might get a person that endorses into California and they've been working for years. They would have to start in California to complete their transition to practice, even if they've been licensed for 20 plus years as a nurse practitioner, providing care out of state, and potentially even independently. So those are some issues that are still kind of a barrier to this pathway to independent practice. And I am sure that as the various organizations work with various legislative staff will see some changes to help with the provider access. But I just wanted to make sure that everybody knew that that was not a BRN requirement. Although we are held to that same requirement, excuse me, it's not something that we additionally added. One of the other barriers to the implementation of AB 890 and access was stated in some of the meetings that the requirement that the transition to practice hours must be completed in the same specialty area that they're nationally certified in and that their education was completed in, that may be seen as a barrier. That was something that our Nurse Practitioner Advisory Committee recommended, and that is something that our board recommended too, for that additional clinical practice and experience to all be in alignment with your nurse practitioner focused education, your nurse practitioner national certification, and that your practice hours should be in that same practice focus and dealing with direct patient care. And that was determined that that may have been a barrier as well. So just heads up on all of that as we kind of continue to do that. So I do have the stats in front of me. Thank you, Marissa. So we've had 4,216 total applications received. We've had 1,603 applications approved. So there is a population of 103 NPs out there that are 1,600 strong. And then we have 578 applications pending. Excuse me. We do believe that that pending status is, awaiting national certification verification. It's pending the provider attestation, and that there is a small group of that pending, which are about 41, that we believe may have had an error inputting their provider information. And so they have submitted a second application with provider information on it. And that becomes a manual process where our staff have to go find that application, match it to their first application, and then get it approved. We have no expired applications. Our applications typically expire after 1 year time period. We're just now coming up on the 1 year time period. And then applications withdrawn. We do have 2,035 applications that have been withdrawn. And what we did when we did a deep dive into that is we found out that 455 of them had issues with their national certification. Again, that goes back to whether their national certification has expired. So they might have been some of the same content areas, and it might have been an appropriate national certification, but they didn't keep it up. And so if that expires, they don't qualify. They have to have a current national certification. If it was a retired national certification, then we would have withdrawn that because they didn't qualify. And so that is within the 455. So this bill, if it does pass, will address some of the 455, unless, of course, they have expired their national certification. The 855 were withdrawn because of provider attestation. There's some kind of issue with it. That doesn't mean that they couldn't get the provider to attest. It could mean that they entered the wrong email address, that they inputted the wrong license number. At the beginning, when we were having applications received, the osteopathic board was not able to, those physicians and surgeons were not able to have their license entered. So we had to withdraw those applications and then have them re-enter it with the correct license number of the osteopathic physician. And then we had 531 where people submitted multiple applications for the same thing. So they kind of went application happy and submitted 2 or 3 or 4 just to see if that would get them through faster. So we accounted for that. And then we did have 194 where it showed that there were other issues. And that might have been on review that their transition to practice was not in California, or their transition to practice hours were completed prior to them becoming an NP, or their transition to practice hours were completed outside of the 5-year time span, which is what Dr. Espinosa was just talking about, or they were not completed in the direct patient care role of the NP's national certification. So That is, again, a small number of those withdrawn, 194, but just wanted to let you know that any of these applicants that have had their applications withdrawn, the 2,035, can reapply at any point, as long as they meet the requirements. We'll go ahead and process it, review it. If they meet the requirements on that new submission, they will be approved. Any questions? Yes, Dr. Espinosa. You are on mute. I'm not.
Yeah.
There.
Yeah, I had a question. Some of the barriers that I can foresee is, I think that the people that would certify a 103 at this point are physicians. And I think that the information that's still out there is still vague and with the wrong information, disinformation. And so many are concerned to sign off when they are, and I'm most concerned for those nurse practitioners that work in family medicine, because those are the ones that we want badly out there, particularly since this was to increase participation in rural communities. And I think it's important that we focus on family nurse practitioner or geriatrics or one of those that is primary care, that we focus looking at that group and how we can help them make those applications. Many people think, many nurse practitioners think, or information I've gotten back is, say they work for an orthopedic physician and they feel, okay, I'm gonna get my independence. That's not one of the 8 groups. That's a specialty that's not added that they could, that they would qualify. And obviously and some of those are nurse practitioners, family nurse practitioners, but they don't have the mentor or they have an orthopedic who can't sign off. So how do we get that mentorship there so that nurse practitioners can, because orthopedics is a subset of family medicine. That was my thought.
I think you said at that last statement, Dr. Espinosa, you nailed it. That's exactly what it was. So it's not that the orthopedic physician cannot sign off on it. They absolutely can. It depends on the individual nurse practitioner's experience. It's not a blanket, right? So as you are correct, that orthopedics is a subsection, and we don't have any regulatory authority over any of the subspecialties, right? So we have to write regulations that talk about the population focus. Family nurse practitioner is that population focus. If that nurse practitioner is working in orthopedics and they can show that they are practicing the direct patient care that is inclusive of what is within the family nurse practitioner, and they have those qualifications and they're able to put that through, and that provider is able to say, yes, that is what has occurred, then that can be put through. What is problematic is when you have a family nurse practitioner who has never worked as a family nurse practitioner and they went straight into med spa and have only done, Botox and fillers and stuff. That person that is very narrowly focused in that aspect does not have the kind of competency levels that family nurse practitioner encompasses. So that is where that provider and that nurse practitioner provider would have a conversation and say, you know what, I don't believe that you meet that. That's, again, outside of us. That is not part of our board's role. Those are the guidelines that are put out there. That nurse practitioner attest that they meet the competency and skill level. That physician does not attest to competency, right? When they're doing an attestation, that physician is only stating that they have completed the hours as outlined in the transition of practice. It is truly just a statement of completion, not a statement of competency. And I think that was one of the misinformations, again, that you were kind of referencing at the beginning, where some of the physicians are nervous and may not want to attest because they think that they are attesting to competency. And it is absolutely not a competency attestation. Sam.
And just kind of piggybacking on what Dr. Espinosa said as it relates to the true heart and spirit of what we had heard over the past couple of years about what AB 890 was all about, was increasing access to care, and increasing the ability of nurse practitioners to provide care in areas where they are so desperately needed. I think that in discussing the legacy certifications is a big part of that, because some of the most experienced nurse practitioners in California are the adult nurse practitioners. And so those are the nurse practitioners, unfortunately, that cannot apply for NP 103. And I think that once we kind of examine that, and whatever happens as far as legislation is concerned, which that's why I wanted the bill specifically mentioned so that people can follow along with it. Hopefully that will be rectified, and then perhaps we will start seeing some movement as NP 103 is concerned.
Yeah, I think so. When meeting with legislative staff as to what the barrier was to allowing a legacy or retired national certification in, it was the requirement that was written in that the national exam must be reviewed by our OPES, and it has to be a current exam that gets reviewed ongoing. That those retired and legacy national certifications do not have a current exam. It's no longer offered, and it would not be allowed. We would not be able to continue to review that. So with the bill language that is in front of the legislators to consider, it makes an exception for all national certifications obtained prior to 2017. And so those national certifications are the retired and legacy certifications. They will not have a exam that would be looked at, and they would not have an exam that we could continue to look at. The certifications that we currently work with will continue to have the review, will continue to have that going forward. I think the one thing to really take away from that is there are no new legacy certifications being offered. So it is a limited pool that has this. And as the years progress, that pool will become smaller and smaller and smaller and eventually fade away. So when you look at it from a public protection angle, we've heard people say, well, you can't look at the exam, you can't keep that going. That's not something that's done. Well, also that population is dwindling as well. So it's not like it's going to continue to grow or be maintained. And I think that is okay.
Thank you, EO Melby. Any other comments from the actual committee members before I open it up to public comment?
I would like to check in with Betha. Betha, are you able to come off mute and everything work this? No, we might need to.
Wait, no, I heard her.
Okay.
Oh, we did.
Right.
Got it.
Thank you. Sorry about that, everybody.
Perfect. We got you all set now. Good. Thank you. I saw everybody coming in and helping you out. So hoping that progress was made.
I also want to acknowledge that Sally Pham is present as well.
Thank you.
Okay, hearing no conversation, I'm going to ask that the moderator open it up for public comment, please.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as the time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Cynthia Yovanov would like to make a comment. 1 second, please.
Hi, good afternoon. Thank you for taking my call. Welcome back, NPAC committee. I appreciate the conversation in regards to the legacy certification. Many of the public members have had an outcry in regards to how the OPES has evaluated those legacy certifications. So SB 1451 does address that. So thank you for that conversation. But what I do want to highlight is really for the NPAC committee. As you know, this bill is out and will be moving swiftly. But the NPAC committee only meets, I believe, twice a year. And this is really for the NPAC committee to really consider that maybe increasing the presence that you guys have to more frequently, the cadence to be more frequent, because of the fact that we don't want an overreach of the BRN without the NPAC having true discussion and insight in regards to this legislative year. So this is really to the NPAC to consider increasing the cadence of your presence from twice a year to maybe 4 times a year, just so that we can hear your voice and have open discussions in regards to this legislative year. Thank you.
Thank you for your comment. Sharon Vogan would like to make a comment. 1 second, please.
Hi, can you hear me?
Yes, go ahead.
Okay, thanks. Thank you. You mentioned that you had a discussion with hospitals or somebody that somebody has an issue with what's on the CVs of the applicants, and that that they were questioning if they should have even been eligible to apply for a 103. But then you said there are no official complaints. So I'm just wondering, what is it that they were saying that made them think that? But they actually have no authority or anything to decide. But I'm just wondering, I'm just uncomfortable that it was brought up, especially since it's not an official complaint and this is an official meeting, because, people walk away with, if people aren't paying attention, they're going to walk away hearing that as a statement of fact. And so I just wanted to, more clarification on that, if you could, please.
Yeah, so I get outreach through many avenues, emails, phone calls, through staff, through our website, and just through meetings, as I'm sure most people do, where they will ask a question. And any time that I get anybody to ask a question about licensees on whether or not they should file a complaint, we always give them access to how to file a complaint so that an investigation can occur. We receive several complaints throughout the month on various things. Nothing is put through until it goes through a proper investigation, gets an accusation filed. Many of those complaints are closed without anything. We do report that. So bringing this up in this kind of a setting, saying that we have people reaching out and that they are asking questions and that they believe people aren't qualified is a natural part of our board's process. We receive many complaints on a daily basis that are unfounded or are not within our jurisdiction. And we do receive complaints that are actual lead to disciplinary action. So they did not provide me specific information. They were stating that what can a hospital do or a facility do when they have a 103 NP that is applying, but when they review them for credentialing, that it looks like their application is not accurate, that they've looked at our website, the regulatory requirements to become a 103. They've looked at their resume or CV, and it does not look to match up. In that conversation with them, I've directed them to talk to the 103 NP. A lot of times CVs and resumes are drafted specific to the employment that they're seeking. and they may not contain all of their work history at all. And so I always refer them to go back to the licensee and have a discussion with them first. And that if they do determine that is something that they want and a BRN investigation to do, we would have to receive an official complaint. I was letting the public know that we have not received an official complaint on this yet. But these are questions that come out. I get scope of practice questions all the time where I'll get people to say, you know what, I have this person here that is doing something. I don't know if they can do that. And I'll say, well, within the scope of practice, yes, they can. But are they competent? Because all of our scope of practice is based on competency. And then again, we refer them back to having the conversation with the licensee to find out if they're competent. That's the same process that has occurred right here. As for the comment where it says, is it up to them? And I don't have it verbatim, I'm sorry, but kind of what I received from that was whether or not these hospital staffers have the ability to look and question that. Everybody has the ability to look and question everything. It's for public protection. We want anybody to question. We want anybody to look, and we want anybody to make complaints if that is what there is. We would rather investigate something and say that it was not founded, not our jurisdiction, or did not occur than have somebody not complain, and then we wouldn't be able to go through and do the public protection. So yes, it is everybody's responsibility to question and ask and make sure that we're all doing what we're supposed to be doing and within the law.
Yeah, right. I totally agree with that statement for sure. Thank you. And to your comment of wondering why only 11% of the NPs in the state have applied. I know tons of NPs that are actually purposely waiting because they want to wait and make sure everything's ironed out, and that they hear it's more of a smooth process. So there might be a large group of those types of NPs too who are just waiting.
I think it will. And I think especially if this retired legacy certification part is smoothed out, I think that it will open it up. But we do still have to get the legacy certification on file. And that seems to be a big hiccup just because we are one of the 2 states that license without national certification.
And is the BRN all ready to go since we already know the legacy issue is an issue? Do you have all those applications like in a group just ready to go when the law passes? Because I'm sure it will pass.
No, they've been withdrawn. And so when that gets put through, we do have DCA's OIS, it's their IT staff ready to make the changes on the application. And with the hope that those are implemented and out by Jan 1, 2025. So typically when legislation's passed, they have an implementation of January 1 of that following year, unless they do a delayed implementation. We have not asked for a delayed implementation. We believe that this would be an easy application fix because since the application's already built, and that would be able to just update and it should be ready for Jan 1.
Great, thank you very much.
Thank you for your comment. Michelle would like to make a comment. 1 second, please.
Was answered. So if your application was withdrawn, then that means you have to reapply again. So that's my first question. Okay, great. And the second, I'm just wondering because it's that they never received my certification, which you have shared has been a big reason for not. So are they reaching out to nurse practitioners earlier to let them know that that certification isn't being it hasn't been received and that they need to reach out to their certifying body again? So because mine was withdrawn, I asked a question the last time we were on and then was told I reached out, and that's why they told me it was withdrawn. And so was a lack of getting the certification itself, not because there was something wrong with it. Thank you.
We do a deficiency statement for every licensee. It is only a one-time deficiency statement. So once your application is reviewed, we let you know what you're missing unless something comes in. And if something comes in, then we'll send you another deficiency statement if it's not the correct, or we'll issue the license. So if you're having any kind of problems, please reach out to our chief of licensing. Her information is on our website. It's Macaulay Fusarin, sorry. And so if you go into contact us, you will see that. I will not try to spell out her first and last name for you. It's better just to go to our website and click on that, and we'll work to get that remedied if you're having an individual issue.
Thank you for your comment. Kathy Hughes would like to make a comment. 1 second, please.
Executive Director of the Nurse Alliance of SEIU California. I guess I'm still confused about the complaints. I thought from your previous comment that you were talking about hospitals, that you were hearing rumors of hospitals complaining that the approved 103s didn't qualify
Correct.
for, from their perspective. And so then, are you saying then that you would expect them to file a complaint against that license of that NP, and then they would have to defend it? Because when you're saying official complaint, I'm thinking, an employer or a member of the public is filing a complaint against a nurse where they would have to defend their actions or whatever, as opposed to the BRN has approved them to be 103s, but the employers don't believe that's accurate. And so I'm just kind of confused, because it sounds like you're talking about investigating it after the approval for a 103 has already been made. And then what are you saying, that then the approval could be withdrawn?
All of the above. So let me explain that a little bit more for you, Kathy. When a person asks us as a question, we've licensed, we always refer them back to their licensee, right? So that's the first thing. So they said that they met the 103, the employer saying no, they didn't. Then we say, it could have been this, it could have been this. You may choose to talk to your licensee, but we can't do anything until official complaint is done. If they want BRN action, they would have to file an official complaint. So I always make sure they know that, because I get questions like says, I think the nurse that I was working with is diverting medications. Okay, well, I can't do anything until you file an official complaint. If we don't have an official complaint, I can't investigate. I can't do anything. So if it's a question of license, and so I'll try to put this back to like the basic RN. And I don't mean basic as bad, because I'm a basic RN. So that's not a bad statement, but just the foundation license of being an RN. We have received complaints that people believe the RN that they're working with should not have been licensed as an RN. And they contact us and say, what can we do? And they would have to file an official complaint. There is right now currently happening, it's called Operation Nightingale. It occurred out of Florida, where academic institutions issued fake diplomas and fake transcripts to thousands and thousands of people that did not complete nursing education. And those people took those transcripts to various states and obtained licensure and are out there working as an RN, and they should not be working as an RN. Some of those have even gone on to advance their degrees and now have advanced practice up to and including nurse practitioners, etc. And they did not have the original RN academic preparation. So we do get people that say, I don't think they should be licensed. I don't think they met our criteria. What do we do? And again, we have conversations around that, and then we tell them that they should file an official complaint so we can look into it. When we look into it, that does not mean that an accusation will be filed. It does not mean that that person will be put on probation. What it means is we're investigating it. Many times we close investigations because there is no evidence that this occurred. So if this hospital or healthcare facilities wanted to file a complaint with the BRN about a 103, stating that they don't believe they meet these requirements, the BRN would investigate, and we would then see if they truly did meet the requirements. The one thing to really be clear on the application process for the 103 is it's not BRN, it's not the BRN's responsibility to see if they meet the requirements, essentially. And I'll explain that a little bit more. The two requirements that we set up for this application to be processed and granted is an attestation from the nurse practitioner stating that they've done this, and an attestation from the provider stating that they've done this. We have asked for no additional documentation to prove anything about transition to practice hours. So based on an attestation, they may not be qualified. They may have attested and they may have found a provider to attest. And so at that point, we would then investigate to say, do you in fact meet the requirements? And if they were granted a license that they did not meet the requirements for, there would be disciplinary action and we would then remove that license. The same thing as if we had an RN that obtained a license and did not meet our qualifications, we would pursue disciplinary action and we would go to remove their license. And so hopefully that helps, Kathy, to really explain that.
Just so you're saying remove that license, are you talking about the 103 part or the RN part? Because that's a huge, because I would say nurse practitioners are filing attestations in good faith that they qualify. If you go back and re-examine and determine they don't, you're just removing their 103 status. Their RN license and their NP license aren't in jeopardy. Is that correct? Or are you telling me it could be all three?
It could be all three. It would depend on what was discovered, right? And that would go through that process. If it truly was an error, there's many different ways that our board handles things. We have cite and fines, we have public reprovals, we have promotion, we have revocation. And so it would really depend on the individual nature. If somebody falsified everything, they did not meet the qualifications, they were malicious, et cetera. They were running a ring where, they had physician that would attest to multiple people, et cetera, et cetera. That's a bigger thing. And all discipline at that point, all discipline is put on your RN license and then any additional certifications on top of that RN license. So it could be, in fact, a very egregious happening. When an investigation is done and they find that it was not malicious, it wasn't negligent, it wasn't anything like that, but it did kind of cross, then it would be decided at that point what to do. It could be public reprisal. It could be cite and fine. It could just be removing of the 103. I don't set that. That's usually done through the court systems done through board decision, but not by me.
Great, thank you.
You're welcome.
Thank you for your comment. Lisa Erickson would like to make a comment. 1 second, please.
Dealing with a cold, so my voice is kind of bad, so forgive me. I wanted to comment, I've been receiving a lot of questions from physicians at my local site about the attestation, and the concerns they have about signing off on attestations is the legal liability if anything were to happen to that NP in the future. And that has prohibited a lot of my physicians from wanting to sign one at this point. So I guess that's a topic to bring forward in the future of the concern of them signing off and the liability as to why they're not wanting to do it for people that are eligible.
Yeah, so we've met with CMA, we've met with other outgroups that are physician specific to really just kind of put out there that it's not competency that they're attesting to. And our legal counsel had an amazing statement, and he may want to clarify this as I go out and put it forward. But it was basically, unless the physician was malicious and fraudulent in their attestation, there would be nothing that they would be accountable for, because it's just a physician attesting to the nurse practitioner completing their transition to practice hours. So if the nurse practitioner said, I completed 4,600 hours with this physician, and the physician has never met them, hasn't seen them, hasn't anything ever. And they say, yes, they've completed 4,600 hours. Well, that physician could be liable. Absolutely. But if the nurse is saying, I completed 4,600 hours with this physician, and the physician says, yes, you have, and they have, then that's all the physician is saying is, yes, they completed the transition to practice hours. And there would be no liability at that point because all of that would be determined factual.
As I think that's something that we can do our best to convey and try to address those concerns in the way that Lori has been saying it. That you know we're clarifying really what the attestation actually truly is, and it's not attesting to the competency or that every single patient treated by that person is guaranteed safe. It's just attesting that those hours were completed. Um, Granted, the reality is, quite simply, in America, anyone can sue anyone for anything. It's there's not kind of a filter initially in the first place that um, filters out meritless cases. I happen to know that because the BRN sometimes gets them. But so we're careful in, we can't say that nobody will ever sue you if you make an attestation, but there frankly shouldn't be liability on the grounds that what Lori was saying, that the physician, if those hours that they attested were actually done, then that's all that the attestation represented, and there was no um, you know there's no real grounds for liability that I can um, really credibly conceive of. Again, that's not going to necessarily stop someone who's litigious and vexatious and all that. Those folks are out there, but that shouldn't, hopefully, won't dissuade physicians who are entertaining the the thought of doing an attestation for someone. It's like anything, you can't, you don't have a guarantee that someone's not going to sue you, but you should feel somewhat assured that kind of knowing what this attestation actually represents. So hopefully that helps. Again, I just reiterate that we are somewhat limited in being able to provide legal advice to medical practitioners out there who are contemplating taking these positions, and so apologize for that.
Thank you for your comment. Committee Chair Gamble Spar, there are no other public requests for comments on the WebEx. We have no public requests for comments in person in our Sacramento location. Would you like me to close this window?
Yes, thank you, moderator, and thank you guys for all your comments. We really appreciate them. And thank you, E.O. Melby, for that report. Thank you. Next, we will be moving on to agenda item 6.0, which is the report of the Impacts Disciplinary Subcommittee on the trends and enforcement issues with final dispositions and disciplinary cases against nurse practitioners in the state of California. Myself and Sally Pham were designated to be on this committee during our last meeting. And so we did have an opportunity to meet and also gather the information from the enforcement code. And I believe that Shannon Johnson is on the call as well. She is the lead enforcement, and I don't want to mess up her title, but she's been doing enforcement for the BRN for well over 10 years, up to 15 years. I think she's got an extensive history. And so myself and Sally Pham had the opportunity to look at the information, ask questions, and help determine trends, in which was in the packet that was sent out as part of the materials. I will yield the floor and see if my colleague who is on the committee has anything to add as far as the process of how we started gathering this information. Okay, hearing nothing, I will have everybody refer to the information that is part of the packet and ask Ms. Johnson to make sure that if I misstate anything, that she corrects me, because I want to make sure that the information is up to date and I'm not giving any disinformation as I present these numbers. So in looking at the trends of what was coming up as far as MP practice, specifically 103, but more understanding as we transition to early next year with potential MP 104s coming on board. We wanted to take a look at the trends that have been happening as far as MP practice is concerned. And so several months ago, I think last year, Shannon Johnson came and gave us a presentation as we were coming up with questions as to whether how this committee would be involved with disciplinary actions as it relates to nurse practitioners. One of the things that kind of stood out to us is that overall, we were told that there may be upward of, I believe, like 700 or more complaints a month that are sent to the BRN, and the amount that are actually in end up in discipline from a trend wise is typically between less than 1% and sometimes less than 2% that actually end up getting disciplined, given the number of nurse practitioners. So this information was presented before in one of the previous meetings. And so just looking at the discipline stats, we went back to 2018 because we wanted to have a really good basis of for a better role as far as research is concerned, a control number to look at as it relates to MP practice prior to AB 890 becoming law. So if you look at the information there, in the first box, you will see the total amounts of actual disciplinary actions, with the most, on average, they're about 51 to 55. And then last year we had a total of 70. And then the actual type of discipline that was provided for each nurse practitioner and where they actually lie at this point in time, or where they were during that year. So one of the things that we noticed is that definitely most of the things ended up on probation, was the largest number. There were some surrenders, some reinstatements. There was only one reinstatement that we saw in 2018. And then the voluntary surrender during the probationary period was typically about 3, and last year we had 6, but that was in alignment with having actually more people who actually had discipline during the year last year. And then as of March 18th, 2024, you'll see the numbers there. There's a total of 8. And currently 4 are in probationary period, 2 have surrendered, and then there's been a total of 5 with public complaints. And then looking at the discipline statistics as far as the violation type. And this is something that we were specifically speaking to when we wanted to look at these trends. How many of them related to practice, how many of them, the 801 practice, which I'm going to let Shannon kind of give more detailed about that, just to make sure, because I don't, like I said, I don't want to misspeak. And because some of this terminology is specific to the BRN and to the disciplinary enforcement task force. I want to make sure that that's thoroughly explained, as well as the OSD, which is out of said disciplinary issues. So, and then you can see convictions, sexual misconduct. And so most of them were either straight related to practice or the 801 practice. And I think I'm going to stop right now and ask Shannon to come on board and speak specifically to these different violation types to make sure that the people who are on this call and the public, that it's well recorded and appropriately defined for you guys. Shannon, do you mind coming on and kind of speaking to different
Not at all.
categories?
Again, my name is Shannon Johnson. I'm the board's enforcement division chief, and I've been with the board going on 16 years now, almost all of it with enforcement, minus 1 year. Excuse me. So in this slide that you're looking at right now, these are all of our practice cases at the top. Those are true practice cases where it's scope of practice. The 801 is when there's been an insurance settlement. By law, anything $10,000 or more, it has to be reported. It's mandated to be reported to the board. A lot of times we get the 801 practice, they settle outside, and but we still have to investigate. And I'm sorry, I'm losing my voice today. We still have to investigate those. So all 801 cases still have to be investigated. We have to obtain the investigation from either the insurance company, the facility, and all necessary records. The OSD are our out-of-state discipline cases. So if you're not aware, any nurse that's licensed in another state, if they are disciplined in that state, the board immediately gets what we call a speed memo through nurses. And we get notified that that license has been disciplined. And by law, our board in California can take action against that license based on the other state's discipline. So those are your out-of-state disciplines. Convictions, those are all of the rap sheets that we get from the licensees who have been arrested. We get the rap sheet the very next morning, and then we get a subsequent when there's been a disposition in the criminal case. Substance abuse disorder, so the SUD, those are our substance abuse disorder cases, and those where we've been able to prove that there is a substance abuse disorder. That doesn't really include a lot of the cases where they were diverting from work or things like that, because most of the time, if they don't admit to it, we can't really prove that. We can really only approve the medication administration, the documentation errors that had occurred. You do have the sexual misconduct cases, and thankfully those are our lowest. And then other, and that's everything else that falls in there. Complaints that we get that maybe are unsubstantiated. We get complaints where she wasn't nice to me, she talked very rude to me, things like that. It falls in that kind of category where we counted, but obviously it's nothing we take action against. So it looks like last year, 2023 was one of our higher years, but if you look at 2024 and where we're at just the first quarter in, it looks like forecasting it out, we're going to be a little bit lower than what we've been in the previous past. We're staying steady, probably 5,000 to 7,000 cases per year that we get. And with the number of licensees, it is a very low disciplinary rate. But as you can see, the 801 practice cases, it's kind of ebb and flow. But the out-of-state disciplines last year were higher than normal. Our conviction cases were higher than normal. Our substance abuse cases seem to remain pretty steady. So I just wanted to point that out. The other slide, you'll notice that our probation cases have gone up, and I believe it was our public reprovals have gone up. However, our surrenders have gone down over the years. The one thing I do want to explain on the voluntary surrenders, so we have two types of surrenders. Normally in our disciplinary cases, the surrender is one of their options for the discipline outcome. But a voluntary surrender, once a nurse is placed on probation, they do have an option in one of their conditions of probation that at any time during that probationary period, they can surrender their license. And we call that a voluntary surrender. So that section right there, that row, is not based on an additional action. Well, it could be actually. If they had a violation, they could say, you know what, I just want to surrender my license and be done. But normally most of our cases, if there is a violation, they go back to the Attorney General's office, and the stipulated settlement is a surrender. So then it falls under that regular surrender column. So I just wanted to explain the difference of those. And I don't know if I explained it very clear or not, but voluntary surrender is an outcome possibly to the probation case.
I think the only thing that I would add is on the slide right above, which was the out-of-state discipline. That means they were licensed and practicing in another state. And that when they endorsed into California or whatever, then that followed them to us. And then on the conviction, that means they did something law enforcement related, whether it be a DUI or something. And so then we get noticed on this through fingerprint reporting. Because we do get live scan reports, we would get what's called wrap back. And we are noticed when there's some kind of proceeding that has happened where there was an arrest made or some kind of criminal activity occurred. And then that is a conviction. So again, outside of us, but we do take action on that.
And then I do want to share also in conjunction with these disciplinary matters, and I know I've mentioned it before in previous meetings, but we have experts. So any practice related case, and that includes our 801 cases, and sometimes our substance abuse and sexual misconduct. We investigate all of those. That investigation then goes to an expert. That expert has to be a nurse practitioner if they were functioning as a nurse practitioner. If they were functioning as a nurse practitioner in oncology, it needs to be a nurse practitioner that has experience in oncology. If it was labor and delivery, same, they would have to have experience in labor and delivery. And when I say experience, there's certain basic standard conditions or criteria that has to be met. They have to be an RN for at least 10 years. They would have to be an NP for at least 5 years. They would have to be currently practicing within that arena that they will be opining on, and they have to be currently still employed in that function. And then, of course, no discipline against their license and so forth. So our nurse practitioners, we have around 50 approximately right now across the state. And no one has less than about 10 years of experience as an NP, which means they have more years as an RN. Our most, she's been an NP for 33 years. So, and the majority of our NPs are at least 15 to 20 years or more with experience as an NP. And then of course, longer as an RN. So I just want to throw that out there that every case is reviewed, and it is reviewed by an expert within that field with definitely enough experience to be making that opinion, because they also have to testify for us in a hearing, and they have to be credible. They have to be a credible witness, and their opinion, they have to prove it and testify to it.
Thank you, Shannon. I think that that's an important context to bring into the conversation. As we were having this discussion during our last meeting, there was some concern from the public as it related to making sure that there was content experts. And so knowing that there are nurse practitioners that are serving as experts that are in the field will help navigate those discussions from a discipline standpoint, and they're nurse practitioners working in that field. And I think that that is speaking to the due diligence of the BRN to try to provide as much context to the conversation and to each case specifically. So I think that unless there are questions specifically, wait, let me yield to my colleague, Sally Pham, who is also on the committee, and see if she has any input.
I had a hand up.
Oh, I'm sorry, Dr. Espinosa, you can go first, and then we'll wait for, I think Sally's trying to come off.
I'll let Sally, I'd like to hear what
Oh, is she
Sally
coming
has
up?
to say.
No, I was looking at the chart, and where it says reinstatement, the last time was 2018, and I was wondering what cases are reinstatement, and I was wondering how do we build a culture of reinstatement more? Because as you look longitudinally, we don't see any more reinstatement.
have reinstatements. They're RNs and just don't happen to have an NP. But we do have more than just what you're seeing here, obviously. Your reinstatements are going to be all of your surrenders and revocations. So if they've surrendered, and there's criteria to that. So if they want to petition for reinstatement, if they have been revoked, they would need to wait 3 years from the effective date of that revocation before they're eligible to petition for reinstatement. If they've surrendered their license and it was for a mental health or physical illness, they would need to wait 1 year to petition for reinstatement. And for all other probationary cases that are 36 months, 3 years or longer, they would need to wait 2 years to petition on a surrender. So there is criteria that is attached to that as well.
In addition to that, the probation monitors and staff work with them and let them know that these are possibilities and stuff. So the people that want to seek it do seek it.
Yeah, there's also another option, a petition option for anyone on probation. So after 1 year of their probationary period, they are eligible to petition the board for any modification of their probation. So whether it be cost recovery that they want reduced, or if they want a change in condition, they can petition the board for that after 1 year.
Thank you.
Yeah, I had a question. Can I speak now?
Yes, Dr. Espinoza, please.
Thank you. One of the things that I want to bring up is I'm listening to all this. This is all good information, and thank you for the extra time that the committee members took for this. However, I did have a question. I thought we were going to look at trends of disciplinary actions as it related to 890, so that those could be filtered out and we can see, okay, what are we doing, or what do we need to do to see what's going on with 890 or what, and I don't see that, and I wasn't here on your last meeting. I'm sorry about that, but I just wanted to get clarification on that.
Yes, so Dr. Espinoza and everyone who's listening, I knew that this question would come up. So so we went live active, I think, January 18th, 2023, and to date we have 1,600 active 103 MPs. And my question when we were having this meeting was, are we specifically monitoring the 103s? Like, how do we know if someone is in disciplinary action specifically as a 103 MP? And so most of the disciplinary actions, first of all, because of the way that California is licensed, you're licensed through your RN. And if I'm speaking incorrectly, Shannon or EO Melby, please let me know, because I want to make sure that this is crystal clear. So the only way that they would know that is a 103 MP that's during a disciplinary phase is during the investigation. So that won't automatically trigger. So for each case, that would mean that it would have to be an investigation per what the complaint was. Am I saying that correctly?
Yeah, and I just want to say, because they have to be investigated, because they're going to be probably most likely scope of practice complaints on that NP, the 103, because they haven't been active for very long, and the age of our casing right now, I'll just tell you, on average, we're looking at about 270 days for an investigation. And that's average. So you're looking at a high end and a low end of that. Low about 170 and high maybe 300. And so we have to obtain all those records. Once we obtain all those records, it then has to go to an expert review. We're probably sitting on about average of 20 to 30 days for that, which isn't very long. But then if the case does have to go to hearing, we're getting scheduled through Office of Administrative Hearings, probably 6 to 9 months out. So that's a good year and a half or so. Right now, on average, we're at about 640 days from beginning to end, from the time we receive a complaint till the time we complete it, if it has to go to investigation and go for hearing. So in order to obtain enough data to really show you any trend on a 103 MP, we're just not going to have that data yet. It's just not, there's no way we would be able to get that for you. If, eventually we could start maybe reporting on how many complaints we've received. Eventually, we can start reporting on that, but then we're not going to possibly have a disciplinary outcome to it. It's just going to be complaints only. And then I wouldn't be able to report on whether or not they were, validated. We were able to, provide evidence to prove that allegation or not. So it's probably going to take a good while to get enough data to be able to report out some good numbers to you guys that are more accurate. I'd hate to throw information out there that, is kind of piecemealed together right now, that we don't have a full beginning end type case data for you.
Did that answer your question, Dr. Espinoza?
Yeah. So my comment now, it did answer my question, is do we need to go through this unless maybe if it's screened by you two on a committee, and if it's something related to 890, couldn't, even if it's a year, or even trends like complaints that might be coming in, which I think this was brought up earlier about some of the things that people have been complaining or asking questions. I think that to me would be more relevant as we're watching 890 evolve. I think it is too early to get statistics related disciplinary actions and how long it may be several years. So I guess I would like to hear more about the trends that were brought up earlier, that people are bringing up, and barriers related to that could potentially lead to disciplinary actions in the future, so that we can prevent that.
So I think in just talking as part of this committee, the BRN investigates 700, I believe 500. They get that amount of complaints on a monthly basis. And I think Director Johnson had even said there's 5,000 for a year. And those are not always just MP based. Those are sometimes RN. So then they would have to segue those out. I do believe that having the subcommittee look into the trends, maybe every quarter, maybe every 3 months, just to keep an eye on things. Because one of the things that we discussed in the last meeting was the concern as people start transitioning to 103 MPs, and kind of how that will overall impact everything as far as discipline is moving forward. And so hearing that not only from the members of this committee, but also from the public comments, I think that it would be in the best interest of the impact committee just to keep up, honestly, because I feel like if we don't do it in kind of every quarterly to kind of look at it, or even, like twice a year, however much we decide. But I think just kind of keeping our eye on the ball is very important as we kind of transitioned and people start making that transition to 103 MPs, 104 MPs, I'm sorry. And then also, depending on what's happening with the legislative climate of California, that could change a whole lot of things. EO Melby, do you have anything else to add to that?
Did you read my body language? Because yes, I do.
Okay.
So one of the things that I really want to make sure that our committee understands is that your purpose for being here is not AB 890 and 103 specific. You are a nurse practitioner advisory committee. That means all nurse practitioner. And in fact, when you look at the statute that brought you guys forward, it says this board shall establish a nurse practitioner advisory committee to advise and make recommendations to the board on all matters related to nurse practitioners, including but not limited to education, appropriate standard of care, and other matters specified by the board. And then it additionally says the committee shall provide recommendations or guidance to the board when the board is considered disciplinary action against a nurse practitioner. So with that said, I don't want this to be a specific focus for the 103. I think that that would be narrowed and not really follow the ask from the legislators with this statute. This statute is for all disciplinary actions and all matters around NPs. So with that said, this subcommittee can meet as often as they want. They can meet with Shannon. They can meet with our legal counsel. They can meet with us as often as they want to get data, to get statistics, to get various inquiries and kind of do trending. And we may or may not see an uptick with 103s. I mean, that's the thing, to understand that the nurse practitioner moving to a 103, it did not change their scope of practice. All it did was remove the standardized procedure requirement. And so that is something that I think we need to kind of keep an eye on as well, is the person that was going to violate their scope of practice was probably going to violate their scope of practice whether or not they became a 103 or not. I don't know that it's going to be tied to the 103. Understanding that the 103 still has to work within a group setting, that 103 still has to work with a physician and surgeon. They are not independent. They don't have a solo practice. That person doesn't exist, that licensee doesn't exist yet. So if we have a person that is practicing that way, that's not going to be tied to the 103. That's going to be tied to the individual nurse practitioner that is deciding to work beyond their scope of practice into the realm of medicine. And they would have probably done that with or without standardized procedures in our prior to the passing of AB 890. So I know that there's been a lot of focus on the 103 NP, but again, I hope that by listening to the previous discussion, we have 1,600 103 NPs in our state, and we have over 500,000 RNs. That is a very small amount. And I don't know that we're going to see these trends or something that we're looking for. The other thing that I really want to point out to is that when we get complaints, we get practice-based complaints. We don't get, there are 103 and they're not doing this correctly. We get complaints on, sexual misconduct, on criminal, where they have a DUI. It's not specific to there's 103. When we get those kind of notifications, especially like the arrests and the criminal ones, they come through on the RN license. So again, it has nothing to do with them being a 103. And so, or even an NP at that point. We find out that they're an NP when we start the investigation. We find out that they have the modifier attached to their license that makes them a 103 NP. And so when we do a practice investigation, and normally our investigators would be like, I'm here at the site, can you show me your standardized procedures? What happens at this point is if they say they don't have standardized procedures, our investigators go, oh, okay, well, you're a 103 NP. You don't have to have standardized procedures. And then it directs them a different avenue. But when they show up on site and they start the investigation and they ask for standardized procedures, if those are given to them and it's a nurse practitioner that's not a 103, then it goes down that avenue. So I think we're putting a lot of focus on this 103, thinking that it's something more than it is. It does not change the nurse practitioner's scope of practice. So if we get a practice complaint, we will investigate a practice complaint. What we can do in the future is, based on the license type, probably develop a report that says these people were also 103s. But unless the person is specifically practicing medicine, essentially without a license, or something egregious happens that is directly related to them not utilizing a standardized procedure, and it's supervision wise, I don't think we're going to see that much of an impact. So I just wanted to kind of put that out there and let you guys know. And again, The complaints that were talked about before, those were inquiries. Those were not complaints. Those weren't even official complaints. These were inquiries, just asking clarification, asking questions. And similar to what you had put forth, Dr. Espinosa, about the ortho one, is I've had ortho people reach out to me and say, you know what, they've only worked ortho and I don't think they're qualified. Well, you don't know their entire work history. And unless you know their entire work history, you cannot say that just because you know them in this setting that they have been working a second job, they haven't been doing something to keep that up there. And that's why we work specifically with the nurse practitioner organizations to say, if you are going through the transition of practice, keep documentation so that if this is ever investigated, you have proof that you did these hours and you did them in your direct patient care area.
Was really helpful. Thank you so much, Ms. Melby. Thank you.
You're welcome. Thank you.
That's a reminder of our job. Thank you.
Yeah, I think that that's an important fact. Thank you for bringing that up because, you know, we are very, a lot of the discussions that we have are based on 103 and then 104, but we are here and we don't, I don't, I hope my discussion did not make it seem like we were trying to target any specific group of nurse practitioners because our job is to exactly as described in the legislation, but also in protecting the public as well. That's our first and foremost thing. So I just wanted to make that statement. Is there any other discussion from the members of the committee? Questions before I have the moderator open it up to the for public comments?
I have a question for Shannon. I thought, maybe I misheard, but I thought like there was 7,000 complaints that come in each month, or is it 700?
No, I was talking about on a yearly basis. It's depending on what you're looking at as far as complaints. When I was looking at the numbers for this, I wasn't taking into account applicants because obviously they're usually not nurse practitioners coming in as endorsements. So I was just looking at the original complaint type and then subsequents, which are complaints that come in on a probationer. They're labeled differently so I can track them appropriately. But you're looking at 5,000 to 7,000 per year. So, you know, we're about 500 plus per month. It just depends. And that's an ebb and flow again. Some months we'll have, you know, 500 complaints and some months we'll have 700. It just depends. At one point on 1 year, we had some really inflated numbers a few years back. And it's just because we had a complainant that decided to file several hundred complaints. So we do get that. We get serial filers. They like to file complaints. But of course, we take them all seriously and investigate them all. They just, I hate to account to that kind of a number in our complaint numbers when it's really not relevant. It really skews our numbers for that year. So I'm going to say on average, 500 to 700 per month. And then, you know, that equates to whatever we get per year. If you're looking at numbers that we actually take discipline on, we send about 80 cases per month to the Attorney General's office. So that kind of puts it in perspective also that, you know, 10% or less, possibly around 10% is getting sent to the Attorney General's office that we're actually disciplining from what we receive.
I think one thing that Shannon, when I first came on board, taught me, because I didn't understand it, just for full transparency, I thought complaint meant accusation. I thought that complaint meant it went on your license and everybody knew about it. Complaint does not mean that, just so that you're completely aware of that. Complaint means somebody has notified the BRN that they think somebody is doing something incorrect. That is in violation of the Nurse Practice Act. We get people that make complaints. You know, I'll do the one that just came through that's complaining that someone was a terrorist. You know, that occurred, and so that's a complaint that's received. We get complaints that come in that say, you know, this person shouldn't be doing their job because they're not qualified. Okay, well, that's the scope of practice. Let's take a look at that. You know, we get complaints that come in that says I was married to this person, I'm going through divorce, and this person told me this, and that's a HIPAA violation. Okay, well then we investigate that. But complaints are not legal accusations that get tied to the nurse's license. Complaints are just complaints received that we get from the public. Once that complaint is worked, an accusation is when it is there's evidence, it's under our jurisdiction, and that is when that accusation is legally filed, and that accusation gets tied to your nursing license. And so that was something that Shannon really had to teach me when I started this role, because I was not aware of those differences. I thought that as soon as a complaint was received, that should go on the license and that should be out there for public to hear, but and see, and that's not what that is. So Shannon, if I butchered that, please.
No, and I also
clarify.
want to add to that, every allegation I said we investigate, which is true. Also, but there's some allegations that we can't investigate because we don't have enough information. They're anonymous. They didn't tell us the time of day, the RN's name. We get a lot of DOEs, RN DOE cases, because we don't know who the RN is. And, we would either go on a fishing expedition to try and hunt this person down. So we do our due diligence, but sometimes we cannot investigate those. And we have to be able to substantiate them. So if we do investigate them and we're not able to obtain the evidence that's needed to substantiate that allegation, which means the Attorney General will not be able to plead that case out because they wouldn't be able to prove it, we have to close those as insufficient evidence. So we do have a lot of cases that get closed for different reasons. They get closed as no violation, which means we've investigated, we've sent it to an expert, and we cannot find that there's been a violation of the NPA. Those get closed no violation. Insufficient evidence. We couldn't obtain all the documentation, whether or not the facility wouldn't provide it to us, it didn't exist anymore, or what have you. We do have the insufficient. We close them and refer them to other agencies. We refer to CDPH, we refer to our sister boards, medical board, pharmacy, BVNPT. So we close them a lot. So that's how a lot of the other cases get closed out, but only about 80 of them, 70 to 80 of them a month get actually sent to the Attorney General to prosecute.
And the 70-80, that's not nurse practitioners. That's
No,
70-80, all of our licensees.
all RNs,
All
regardless
RNs.
of APRN or not. That's
Yep.
total. So out of our over 500,000 RNs, 70 to 80 get sent per month for prosecution of the license.
Thank you for that clarification. Any other feedback or statements from the members of the committee? Okay, hearing none. Moderator, will you please open for public comment, please?
Public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will now give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Sharon Bogan would like to make a comment. 1 second, please.
This is Sharon Vogan. I'm a family nurse practitioner from Oakland, California. And I was looking at these statistics. Thank you for doing the work to get them on the discipline statistics. And I'm wondering, so each number represents a type of discipline or a violation. And so I'm wondering how many NPs are represented in these numbers. Because if somebody is on probation and then they voluntarily surrender during probation, is that person counted twice? And then the violation type, there could have been that an NP violated some sort of practice, and they also had another. So I'm just wondering how many NPs are represented in these numbers.
Shannon, those numbers are all NPs that are part of our
I
materials,
didn't know if
right?
you wanted me to respond or not. So those numbers that were represented in those tables, those are NPs only. And if the NP had double cases, so for instance, we'll get a nurse practitioner that has, we got a complaint from an arrest notification, then we got a complaint from someone of the public along the same lines, or we, more than likely it's going to be, we had say 3 facilities file 3 different complaints against the RN. We basically kind of merge them all into one complaint to get investigated. That one investigator does all 3 facilities. We consolidate those. So even though there's 3 complaints, that nurse is only represented in these numbers once. The voluntary surrender is broken out for a reason, because that is not considered an additional violation necessarily. They have that option during probation, but because it is closed out with a surrender type code, we want to go ahead and show you, look, these nurses were placed on probation. So out of that number of put on probation, the number below it on the voluntary surrender, that's when they did it, but that is fluid. So understand that if I went on probation last year, that probation discipline is going to get counted in calendar year 2023. If I want to surrender today, that voluntary surrender based on my probation condition is going to get counted in calendar year 2024. So that's fluid because it rolls over those, and we're displaying calendar years, not fiscal years. So I want to make sure that that's clear, but the numbers on those tables are NPs only, and there are not duplicate transactions within those tables.
Okay, so I know the numbers are NP only because that's the title. So I just want, so you're verifying that 70, the number 70 means there's 70 individual nurse practitioners that make up these violations.
Yeah, so this is out of the total number of certified nurse practitioners within the state of California that have had complaints filed against them, but these are only the disciplinary actions.
Right. I just, so the answer is yes, then, that the number 70 represents 70 people.
Yes.
Not
Shannon,
just 70 violation. Yeah, okay. That's all I was wondering.
this is Reza. Sorry to interrupt. One piece of clarification, where it's like in the 2023 column, the total is 70, and the number for voluntary surrender during probation is 6. Could that 6 be? Is there like?
Yeah,
That's
and
no.
that's what I meant. So the voluntary surrenders do not count against that total. I mean, the total number, you would lower it then. So for instance, if there's 70, and I don't have that screen up in front of me right now, I apologize. But if the total number is 70 and there were 5 voluntary surrenders, more than likely you're going to change that. So really there were only 65 disciplinary actions.
Yeah, I'd suggest to the commenter, just, take the totals line with a grain of salt as far as it representing specifically that's, for example, 70 different individual NPs, just due to that minor issue of the possible overlap, what Shannon was mentioning. It's the number of actions that the BRN took. So 17 public reprovals, 24 probation, etc.
Okay. So 70 isn't representing 70 people. It's close, but
It's close.
okay. And I'm just asking the question because it seemed like some people were concerned about the number of licensees, making violations. And so I just wanted to make sure all the statistics, the numbers in the statistics are representative of what we're talking about. So thank you.
Thank you for your comment. Kathy Hughes would like to make a comment. 1 second, please.
With the Nurse Alliance of SEIU California, just a quick question. Can you briefly explain what a public reproval is? Just so I kind of have a picture in my mind. Thanks.
Shannon, that's on you. She's on mute.
I was trying to unmute and I couldn't get it unmuted. So a public reproval is the lowest form of formal discipline. So when you're looking at disciplinary actions, and maybe I should just explain overall how a case would go. Some cases that do not rise to the level of formal discipline would go to our citations desk, and they would get a citation, which could include an order of abatement. So if somebody maybe is using the credentials NP and they shouldn't, they may get sent a citation for an order of abatement or some really low level actions that have taken place. We will send for a citation or order of abatement. That is not formal discipline. Then you have your formal discipline. Your lowest level of formal discipline is a public approval. They used to call it a public reprimand. Basically, it's only out there well, I shouldn't say out there. It's published for 3 years on our website. And then the documents are removed. However, through the Public Records Act, you can still request the documentation. Usually with a public approval, you only have cost recovery to recoup the cost of the investigation. Possibly, we will assign courses as well. So if there's remedial education that's needed, we will assign courses to a public approval. The next level would be your probation, and that's where you have your option of standard conditions of probation and then additional conditions, which include all your substance abuse conditions, mental health. After that, you would have your surrender and revocation.
And then, sorry. I had nothing more to add.
We have a retention schedule on our website as well. If you wanted to see how long the board retains documents on our website, and just so you know, we post to both the BRN's website as well as nurses. Once the retention, based on the disciplinary action, once we hit that mark on that date for retention, we remove the documents. However, all documents are always accessible through the Public Records Act.
Approval is authorized under Business Professions Code Section 495 if you were interested in the authority.
Thanks. I'm not sure if I'm still not muted, but that answered my question. Thanks so much.
We hear you, Kathy. Thank you.
We did. Go ahead.
This is Member Beth Schnelly. Am I able to make a comment, or is that okay now, or should I wait? Yeah, yes, it's okay?
It is okay, yes.
Okay, thank you. Just a thought about the disciplinary action and our role and the oversight of it on the BRN. I just feel like I'm missing potentially quite a bit if I'm not able to see patterns of ones that are not brought to full disciplinary action. If there's, I think you said 500 or more a month, and only 4 to 5 actually are found to have merit. I just feel a little bit uninformed, though, that I have no concept of the patterns or reasons for finding no fault with any of the other 500 that don't make it to disciplinary action. So it's just a sort of a thought or a question for the other panelists, if we should be playing any role in at least looking at the patterns of those hundreds and hundreds of other complaints.
Those are, so again, just to point that out, that's RN in general. That is not nurse practitioner specific. So we would only be reporting out data on those NPs and to this committee. Now, to our board, we do have an ability to report out on all of them. What we would more than likely be able to report out would be closed no jurisdiction or closed insufficient evidence. It would be fairly impossible to report out the individual detail, and some of the complaints that we receive, like the one that I reference, is they complained that the person was a terrorist. you know, and to be honest, I was that person. They complained that I was the terrorist, right? So it that's a complaint that's received, right? And so to report out stuff like that at that level, it really kind of skews what the focus is, and that is public protection here of stuff that is actually something that can be done to affect change.
And maybe to clarify my ask, I would not
Okay.
want that level of detail either, but
Okay.
perhaps the buckets that it falls into, like, are there 400 that are being found no merit that are, sexual misconduct? Like, what are the buckets that, the same buckets you showed us earlier, maybe,
So
but with the
I could create a table showing the total number of complaints for the month or the quarter or the year, how many were closed. I can show you the number of each closure type. So no action taken, insufficient evidence, those types of closure codes. And then narrow down underneath that just the nurse practitioner. So if you want just a high level of all complaints, I think that would be the easiest way to do it. And I can run that without someone having to do a manual count or read through a bunch of summaries, things like that. So total number of complaints received, total number of closures, maybe total number referred to the Attorney General's office, and then the closures I can break down by closure type. And then if there's anything that you would like to see more on the two tables that you have here, I'm going to start, and it was mentioned earlier today in the Nurse Midwifery Committee. I used to present these tables for each of the certifications, but on a more high level for the board at the board meetings. And I'm going to start beginning to do that again. So you'll see a high level overview, and it'll basically be based on fiscal year or calendar year. And then it'd be not a comparison, but it'll break out all the different certificate types and then how many disciplinary actions were received. And it's broken out by different types of discipline. So you'll see all the nurse midwifery, nurse practitioner, and then whether it was a revocation, surrender, probation, etc.
I think that would be helpful. I defer to my other panelists though as well, but I would also ask, would it be possible to bucket those complaints in the same way that you bucketed the previous slides, to say, okay, 50 were closed in the sexual harassment bucket, 50 were closed in the 5 buckets you showed earlier, to just show the number that are being closed in each of those buckets. So, because if we see some discrepancy in percentiles of those being closed, that might raise a flag. I guess I again defer to my other panelists, but I think we would need the buckets for it to be useful.
Anybody else have any input?
I think we could do that, Betha. Let me work with Shannon. Let's see what we can come up with. And we'll let Samantha and her committee do that. Board moderator, was there more public comment?
Yes. Board moderator, do we have additional comments waiting in queue?
Just because I know we only have 30 more minutes left in an agenda item to go.
Right.
Again, I need to learn to unmute.
You do.
No, we do not have any more public requests in the WebEx, and we don't have any public requests in person either.
Okay. Hearing that, let's close the public comments at this time. However, before we move on to the final agenda item, just to tidy this up with regards to the request from the committee member, Betha Schnell. I think that you guys are going to work together. We'll come up with something with Shannon to try to get maybe a trend on the level of the complaints coming in, and work with her and maybe be in alignment with the same reports that the midwifery committee is receiving. So that just for tidiness and for equivocal reporting, I guess is the best way for me to say that. Okay, moving on to our, sorry, EO Milby.
Just so you guys know, it is information only, so there's no vote that needs to happen, no motion or second.
Right. Moving on to our last agenda item, discussion and possible action regarding input from the Impact Committee on possible changes of the BRN disciplinary guidelines to provide recommendations on guidance on care when the board is considering disciplinary action against an NP. And so that leads right into from our previous conversation with regards to how much input as it relates to total NP practice and recommendations for the board. Before we had mentioned that we wanted to formulate the previous subcommittee as far as discipline is concerned, and then look at the trends and decide from that standpoint if and when there would need to be any specific input on an individual basis. I think we decided against individual basis, secondary to due process for the people who are going through the process. With that, I'm going to halt that statement and open it up for my fellow committee members to have any input and to open the discussion.
So additionally, if you guys scroll down onto page 24 of 24, you will see some text that has been inserted there. The text that is underlined is new, and what we would like you guys to consider and take input on. We did present this to the Nurse Midwife Advisory Committee, and I will, Marissa Clark, my Chief of Legislation, is here and present, and she can kind of give an overview on how that went so that you guys can see the feedback that we've already received on it. When we were looking at our disciplinary guidelines and we're looking at the independent practice of our advanced practice RNs, all four categories, nurse anesthetist, nurse midwife, nurse practitioner, and clinical nurse specialist, we do not have the ability right now to allow for those individuals with a independent or solo practice to continue to practice that way while on probation. And so in order to ensure that people don't have to quit their job, sign over their business to another person while they're on probation, et cetera, we looked at these guidelines and said, what section can we update to allow for this to happen? And then because you guys opine on all things nurse practitioner related, you guys are part of the APRNs, we are bringing it here to you guys to have discussion on this. And so at this point, Marissa, if you want to share kind of more background on that and then share what the Nurse Midwife Advisory Committee had already kind of shared this morning, then we can open up for further discussion.
And everyone. So as Lori said, this topic had come up before in previous meetings and was identified as an area that guidance was probably needed. And so what I did is went back and tried to kind of create just something for you folks to react to, just a starting point. So this is really the very beginning of the regulatory development process, probably similar to what you went through with AB 890, where we start fleshing out language and then we just go through the iterations of getting feedback, incorporating feedback, getting it, and incorporating it. So the starting point we used was looking at other boards and bureaus that regulate independent practitioners and kind of saw what type of language they have when it comes to probationary settings for folks that are in their own kind of independent location. Obviously the med board being one that relates pretty directly. And then also looked at our existing disciplinary guidelines to make sure whatever we were doing wasn't overly stringent or overly broad compared to how we would deal with a standard NP. And so met with our legal and then met with our enforcement. And we also reached out to the Attorney General's office and got some of their input. And what you see in front of you is really just a starting point. We kind of put together all of that language, tried to align it with the existing DGs, just so you would have something to kind of look at and say, we like this, we don't like this, we need more of this, we want less of this. And as Lori has said, the underlined version would be that new language. The non-underlined version is the existing condition 8 within the disciplinary guidelines. So you'll notice some of the language is similar, along with, like I was saying, trying to keep it consistent. That is something that the NPAC did weigh in on, because they were had some input on the wording around maximum, moderate, and minimum. And they had provided some recommendations on maybe adding some more clarifying language on what those things could entail as it relates to the level of supervision. So they provided some suggested potential amendments of using language like directly supervising patient care. And that would mean, you know, they were in the room, or present in clinical setting, which could mean that they're on location, but maybe not directly in the room with the provider. And then the least restrictive being like readily available. So that could be someone that is offsite, but is someone that can be connected with easily. So they had suggested those as terms and phrases that they see more commonly used in practice. So we jotted down those notes. Also talked about clarifying under the minimum how we're communicating. Is it on-site? Is it off-site? And really kind of going a little bit deeper there. And then also brought up for broader discussion, who would be kind of, for lack of a better phrase, footing the bill for this supervisor, for this worksite on-site monitor, and how would that person, would they be paid? Would they be volunteer? And if they were paid, where would that money come from? And would there be any conflicts of interest depending on who was putting that money out there? So we jotted all those down. They were kind of looking at it, obviously, from the lens of how this would apply for nurse midwife. So now we bring the exact same thing to all of you to look at in how this would apply for a nurse practitioner who would be operating an independent setting in the future. So we'll open it up and happy to answer any questions.
Yeah, one area of clarification, the non-underlined or just the regular text, that is our current disciplinary guidelines, and that is for all RNs, NPs, midwives, CNSs, CRNAs. It's for every single one of our licensees. And so it is very generic. And that's why it does have the maximum, the moderate, the minimal supervision. And it doesn't specify, you know, independent or independent settings or stuff like that. It does talk about shift work. It's very broad. And then of course the underlined is more geared towards our APRNs only. And so these are meant to be for the independent advanced practice RN. I know one of the amendments on number 3, where it says minimum, the individual providing supervision as person-to-person communication with the respondent at least twice during each shift worked. Discussion was to not use shift to talk about the hours worked, because of course, if you have your own clinic, it's not a shift. You're not always employed at a hospital with shifts. So that was heard. We had that in 1 and 2, but I think it was just an oversight or a miss on number 3. I don't think that was intentional, where we just talked about the independent setting at all times, or at least half the hours respondent works, etc. So that was heard. And then when we do probation, we take a look at every single individual case. And so the nursing education consultant is tasked with approving all work settings prior to the person being able to be working in those settings while they're on probation. So they get org charts, they get job descriptions, they get contact information for administration, etc. And that works really, really well with your traditionally employed RN. Because they do work within hospital settings, they do work within clinic settings, and they do have supervision, they do have org chart, etc. With this, we could potentially get an org chart showing that this person is the owner of their own company, and that they report to themselves. And so at that point, we would have to have some kind of a monitor in place that is not them, because the goal is, and I believe Shannon put this at the last meeting, was rehabilitating, getting them back into the workforce, not blocking them, but maintaining public safety. And so this would be a possible path forward for that. And so it's Shannon, if you wanted to elaborate more on that. You can.
Stating that, for our goal for probation is to ensure that we're rehabilitating these nurses if needed, getting them back into the safe practice. And so in doing that, we want to make sure that we have language set in place that gives us the flexibility to monitor them in a full capacity. Because if you're going to allow them to complete probation and then have an unencumbered license and tomorrow go out and get a job in any capacity as an NP, you want to make sure that you have monitored them, not only in that capacity, but in whatever capacity that their violation occurred. So if they're having difficulty or struggling in a particular area within their scope, you want to make sure that they're monitored efficiently during that time. That way, there's no question when they complete probation that we're releasing them back out with an unencumbered license. So we need to make sure that within the language, it gives us that flexibility to do that. So whether it be an independent practice or not. And then a comment was made before too of, making it very specific to, or why can't, this certificate type have its own disciplinary guidelines or its own conditions of probation. And I just want to point out that all of the conditions up through 1 through, I believe, 5, 6, 7, 8, 9 is all employment. And then from 10 on is all of your other conditions, including substance abuse, mental health, abstaining, doing random drug testing, all of that. So those are all apply to all, regardless if you have an APRN or not. So really the changes that you want to look at, that we need language change on, because as you all know, over the last, these haven't been updated for a while, and over the last 20 years, quite a bit has changed. And with that in mind, over the next few years, more may change. So you want to leave it flexible enough for your future and change it for us to be able to work with it today. And so all of those other conditions, because they apply to all regardless, they don't really need to be tailored to specific APRN, but the employment does, and the courses. So if you want to change any language based on rehabilitative education, you may want to look at that as well and keep that in mind.
I have a comment. This is Kevin Maxwell.
Yeah.
I think it would be very important to make sure that there was no financial conflict of interest and have it spelled out that that I don't know, if the person were required to pay for someone, that they're not going out and hand selecting someone to be supervising them, and that there not be any way for, or maybe even just have a statement in there if you were going to delineate that there not be a familial relationship with someone, that maybe there's not an existing financial relationship between the two parties, so that the person that's doing the supervising is truly going to be independent and not beholden to them.
We currently have that in our attestation. So for any employer that is going to be a worksite monitor, we have different attestations. We have one for the employer and we have one for the worksite monitors, because it could be two different entities. Within that attestation, they are attesting to the fact that they do not have a personal, familiar, or financial relationship with the person that they will be monitoring. So that is in every attestation that we receive from both the employer and the worksite monitors.
And that also came, oh, sorry.
I'm sorry. Go ahead, Marissa, go right ahead.
Oh, sorry. I just want to add on that also came up in the NMAC discussion. And when we were discussing this as kind of putting it together, initially we had talked about putting that in there. The only reason it gave us pause, and we can definitely add it back in, was we didn't know if there would be a scenario where the NP would need to pay for it, and if that would be limiting language, whether or not. And so that's why we took it out. That being said, I think everyone kind of agrees, like, we don't want a conflict of interest, but then how do we ensure that we're not accidentally putting kind of a barrier there? So just for consideration.
I guess that kind of lends into the question that I was piggybacking off of Kevin's question was, currently when APRNs are in, specifically MPs on probation, And there needs to be, who pays for that right now? Is it the employer? Like, how is that divvied out? Or they're still allowed to work and they just have supervision? And, but this is going to change as it relates to the independent practitioner. So I guess knowing what's happening now will maybe help us determine what needs to happen next.
Doesn't happen because we don't have this provision, right? So when a nurse practitioner is disciplined, they have to have direct supervision. And that is by a person that is equal licensure or higher, or they can't work in that setting. And so that is the issue. And so we will have people that will have to seek out a different job, or they will transfer the license of their business to somebody else, or they will stop operating that business during the time that they're on probation because we don't have these provisions. And that's why it's important to get these type of provisions moving forward to address that, because we will have more and more independent practitioners. When you look at like the nurse midwife, there are quite a few that are employees of a healthcare institution, work within that. And so that works out well for them because there's more nurse midwives that they're working right there along with them, and they're on site and they're part of a hospital association or et cetera. The same thing with nurse anesthetists, right? They work as part of a surgery center. They work providing anesthesia services, as part of a larger organization. It's not typically they own their own clinic and they do that. So that independent practice, when on probation, have kind of built-in supervision as part of their employer/employment, right? What becomes problematic is now the new independent practitioner that has a solo practice. And so we have to have a path to manage that.
Thank you.
And I see Dr. Espinosa's hand up.
Okay, sorry, I can't see you, Dr. Espinosa. Go right ahead. My apologies.
No, not at all. Thank you. My understanding for the medical board for physicians, when I've been asked to supervise somebody, the cost has been on the physician or the person, the respondent, the cost of, most of the time we do it as voluntarily, but it is upon the fees or whatever that you have to, if you have to have a supervisor, is on the respondent. Now, they do ask always, whoever is going to supervise, do you know this person personally? Have you vacationed with them? Are you their godfather? Whatever that may be. They do ask this and then disqualify you and have you sign a form saying, I do not have a relationship other than collegial with this physician. But the cost of that falls on the respondent, at least for the medical board, has been my experience when I volunteered.
I agree, because like if you're an independent MP 104, and let's say you get disciplined, how would you go about getting someone to supervise you? So the cost would then, so there got to be like a standard of how much, in terms of finance is acceptable, right? So I don't see, it's going to be much harder to find someone that's going to volunteer their time to supervise without the financial without paying someone to do so, like the medical board.
I think that there's an option to pay, which is why we did not put that there couldn't be a financial agreement, is because you do have to facilitate for those one-offs. But Dr. Espinosa, didn't you share that with the med board that a lot of it is volunteer based, that it's not financially? Are you on mute? Or I'm not able to hear Dr. Yeah.
Yeah, my understanding when I volunteered, they asked me if I would volunteer because this person was a colleague who I didn't know very well, but well enough as a colleague. And as a courtesy, I did it without cost, but it would be the board made it clear that whatever cost there was, it would fall on the respondent.
Yeah, because the board does not pay
No.
for that. No, that would be the respondent's responsibility. Or if they did not do that, then they wouldn't have the workplace monitor specific for independent practice, and they would have to then drop down essentially in the supervision aspect, and have a job that has that supervision. But again, to Shannon's point on that is, we want them to work to the capacity that they're going to work when they get off of probation, as similar to that as possible. So to facilitate the independent practitioner in the solo practice area, that's really where this would need to move.
Any other questions or discussion from the committee members? I do want to bring to everyone's attention, it is 3:21. I would like to open this up for public comment at this time, if we're able to, if no one has anything else. Oh, I'm sorry. Jan, I see your hand up.
It's just a real quick question, which is on the minimum, it talks about person-to-person communication. And I'm just wondering what that's interpreted as, is that it doesn't say face-to-face. Does that mean it could be by telephone or by text message? Is that what's intended there?
I think we can clarify that more specifically. But sometimes it is, so like we have a provision in the other with RNs where they can do home health. So if their job is home health and that's something that's been approved, sometimes those check-ins are done via phone. And so they will do a phone check-in, they can do a FaceTime check-in, or any other, Zoom or Google Meets or anything like that. It doesn't have to be specific to an Apple iPhone. But they can do those kind of check-ins. But then additionally, they'll do spot check where they will show up in person, and do that. So when we get down to minimum supervision in the current way, we check in 2 times a shift. That can be that they walk over to the unit that you're at, or they're on site, or it doesn't specify, because again, we're looking at many different work environments with many different types of practice occurring. And so when we set up the probation, we take this as a starting point, and then we work on specifics with the probationer, with the probation monitor, with the employer. There is no possible way, with the vastness of nursing, up to and including the advanced practices of nursing, that we can do a one size fits all. And so if that's something that you have concern on, that person to person is in person, then we could offer that up. But I don't know that in-person supervision would be able to be carried out for all people in these type of practice settings. And one example would be, what if they're a telehealth RN? They're a telehealth advanced practice, NP. So you're doing telehealth under your California license, but you're physically located in Nevada, and you've got a person that is monitoring you. Your work site is your home because you're doing telehealth, right? How would you do a in-person check-in? So that's why it has to be person to person, and that person to person would be determined by looking at that place of employment, looking at the employer setup, the job responsibilities on what that would look like. So I don't know that we would want to be incredibly prescriptive at this because it would be a barrier to a lot of different employment possibilities.
Okay, so there are two questions that come up for me then. One is, do I understand what you said, that each probationary situation is crafted to that individual so that this could then be a step down, that you would, timeframes I don't know, but let's say it goes over a month, you've got a week of maximum, you've got 2 weeks of moderate and a week of minimum. Is that what goes on?
So it is a 3-year probation. Typically, they can petition for early termination. Early probation. Sorry. They can also we can extend it if there's any kind of violation. I've seen them go out to 5 years, etc. And yes, it is correct that it's individualized. We get the decision and order through the legal process, the court process, right? And so that decision and order tells the person that are doing these job placements what occurred, what the violations were, what are any mitigating factors, etc. Then the probation monitor works with that licensee when that licensee is looking for a job. So they had their license revoked and then reinstated, or suspended and reinstated, whatever, and they now have a current license. All of their employment must be approved in advance. And so they'll send us the org charts, they'll send us the name of the company, the address of the company, they'll send what their duties are, what their job responsibilities, what their fitness for duty is, etc. And all of that is reviewed by a nursing education consultant that works within the enforcement division. And then based on that, they reach out to the employer and have a conversation. Again, if this is an independent practitioner, they'd be reaching out to that independent practitioner to find out what kind of monitoring is being set up and then go over the requirements for that. But it's all individualized.
Okay, well, so I can see, since one of the goals behind having 104 status was that there were going to be services available where they currently aren't, rural settings, remote settings. That just isn't an additional layer of complication, I'm guessing.
It would be an addition. Yeah, it would be additional layer, but the NEC would take that into consideration and work with that to see what would be the safest way to get this person back to work.
Okay, and hopefully not closing down their practice.
Absolutely, and that's why this provision being added into the disciplinary guidelines will facilitate that.
Yep. Okay. Thank you very much.
Thank you. So if you guys, similar motion, the motion that the Nurse Midwife Advisory Committee made was that they're okay with this language with the amendments that they had suggested, and that they wanted to see the language come back in the future. And that is the process. So if you guys made a similar motion, what occurs is this language with the amendments from the Nurse Midwife Committee, the Nurse Practitioner Committee, is going to go forward to our Nurse Practice Committee, which is a board committee. They're going to look at the language and they'll provide input as well. And then based on all of the input, we will move with this package. And as language is revised and flushed out, anytime that is done, we will bring it back to you guys so that you guys will see exactly what's happening as this moves forward. The board will eventually decide on language that they want to actually move forward with. And then we will start a package at that point, get it through. And when it gets to the point where the board has accepted the language, then there is a public comment period time that opens up, and then we'll hear more from the public at that point. But I know that we're up against time. So if you want to do a motion in a second, we can go out to public comment.
Does anybody have a motion? Well, I can make the motion myself. I motion that the Impact Committee accept the proposed draft of the probation condition number 8 as it relates to independent practitioner supervision, with the stipulation that the language will be returned back to the committee for further review. May I have a second?
Dr. Ray, second. Perfect. Okay, board moderator.
Yes, please take us to public comment, please.
The comment now, please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give you reminders as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Gambles Farr, there are no public requests for comments on the WebEx. We have no public requests for comments in person in Sacramento. Would you like me to close this window?
Yes, please. Thank you, moderator.
Thank you.
And so with that, we will have a vote. Myself, Samantha Gambles Farr, yes. Vice Chair, Dr. Edward Ray,
Yes.
Nurse Practitioner Sally Pham,
Yes.
NP Jan Johnson Griffin,
Yes.
Dr. Andrea Espinoza, NP Kevin Maxwell,
Yes.
and Public Member Betha Schnell. Okay. And with that, we have the motion has passed, and so we will push that regulatory language on and be looking forward to it coming back. The time is now 15:31. We are 1 minute over. Really appreciate everybody attending the meeting today. We appreciate all of the BRN staff members for assisting us along the way. And with that, I call this meeting adjourned. You guys have a great day.
Thank you,
Bye-bye.
guys.